Okay, so welcome everyone to Independent RX's monthly webinar. We do these every month. I'm Owen Bondurant. If you don't know, I'm a partner and one of the founders in Independent RX. Myself and Tim are partners in this business, but we also own a couple pharmacies, compounding and long-term care. Independent RX is a company that helps people start and buy pharmacies. We do accounting for 130, 140 pharmacies, and we help people sell pharmacies as well. Tim Clark's my partner. We are recording this webinar and we'll send it out on the various channels, email, our website, LinkedIn, etc. There is a Q&A at the bottom. If you want to ask questions, we'll answer those as we go or at the end. We'll answer as many of them as we can. We are fortunate enough to have Day and Lucas from Buchanan on the line. Tim and I actually use them personally for some of our stuff, and they're here to talk about audits and various other issues. Day, Lucas, you want to do a quick intro, I guess?
Sure. Thank you, Owen. Good afternoon, everyone. My name is Dae Lee. I'm a pharmacist attorney. I'm a shareholder at Buchanan Ingersoll Rooney. Today's webinar is educational only, not a legal advice. So I'm not giving you my legal opinion. We would be more than happy to set up a call or exchange emails if you have any legal question. I'm sorry, I had to say that because we're we're attorneys at the end of the day. We are bound by the professional rules of ethics, and we're required to say that on any webinar that we give out. I mainly help out independent pharmacies in their dealings against, the PBM, right, the vein of our lives. And I help independent pharmacies from audits to investigations to, change of ownership issues or network suspension or termination issues. And I work very closely with Lucas, and we are in a same team, and then we defend, pharmacists' rights. Lucas?
Thanks so much, Day. And thank you, Owen, and thank you, Tim. Really appreciate the opportunity to present to you all on these topics. As Day said, we work very closely together. And generally speaking, I would say that the vast majority of the work we do is on behalf of pharmacy owners and pharmacists throughout the country, and very specifically independent pharmacy owners. So we know that it is not a level playing field out there. And so one of the things that Day and I really pride ourselves on is doing everything that we can to level the playing field and using every tool in the legal toolbox, whether it's contract law, federal law, state law, so on and so forth, to make sure that every pharmacy is afforded the very many legal rights that they truly have. Although sometimes it'd be hard to tell if you read a PBM contract, but those rights exist nonetheless. I've been doing this for about 11 years. And the one thing that I would say that, sometimes Day and I do together where there's overlap, but sometimes a handoff, so to speak, is I also do a lot of work that is actually true blue litigation. So litigation can come up in a couple of different venues or contexts: federal court, state court, and also I'm sure you're familiar with the notion of private arbitration. And that's really a reflection of the different dispute resolution provisions contained in the various provider manuals. But we often will find ourselves in federal court if we're dealing, for example, with the likes of Express Scripts. That's because they have a venue provision in the state of Missouri calling for litigation in the federal district court for the Eastern District of Missouri. With many other PBMs, we find ourselves in private arbitration with the American Arbitration Association, or JAMS. So I have extensive experience with that. But I will tell you, at the end of the day, our goal is to get you in a position to not have to go there. It's a last resort, but if it's necessary, we are fully versed in that process. So that's a little bit about my background as well as Day's. So as we get started here, just to first talk about some of the learning objectives here, I want to talk about some PBM audit trends and also importantly, the legal tools available to you to navigate those PBM audits and to survive these trends. We're going to talk about some additional trends that we're seeing separate and apart from PBMs, but still potentially having implications in the PBM realm. And that relates to AstraZeneca and Farxiga. And then also we'll conclude with discussion of BOP, or Board of Pharmacy, State Boards of Pharmacy. That's another area where I have a heavy focus, and Day does as well, especially him being a pharmacist. So we routinely are navigating the Board of Pharmacy space, which is much, much different from dealing with a private corporation like Caremark, Express Scripts, or OptumRx, but still a very, very significant part of maintaining a viable pharmacy operation. And we'll talk about some inspection and investigation trends we're seeing there, as well as also associated legal tools available. And then the one thing I'd say is, if it's not already apparent, these things all intertwine. It's really like a Venn diagram of relationships. So these are some of the things that we really want to emphasize. So with that, we'll transition into discussion of PBM audit trends, and I will hand it off to Day.
Thanks, Lucas. As you guys know, there are multiple types of PBM audits, starting with the on-site audit, desktop audit, and then fraud, waste, and abuse investigation. On-site audits usually scheduled. You get a notice of on-site audit where the PBM is going to provide you with a prescription numbers, but they're going to mask the last two or three or even four digits. So, and then asking you to pull all those prescriptions ready for their auditors. And then they're also going to ask you about signature logs and proof of payment. Again, it's a scheduled process, so you should have not enough time because they're going to send it to you maybe 14 days advance while you're, busy treating the patient. But they're going to give you a notice, right? And then they're going to look through the records that you prepare. They're going to go back and then issue the initial findings after the on-site audit is completed. Okay. But one thing that I wanted to highlight is that when the auditors come, they're only allowed to look at documents and items associated with what's been asked under the notice of audit. They can't log into your software system. They can't flip through other records that you may have, and they should not do it. Okay. And if they try to push, then you have to stand your ground and say that it's not part of the audit. It does not fall under the realm of the audit at the on-site audit. Okay. And it's not gonna just because you push back, it's not gonna get you in trouble. Okay. But you have to be ready for the on-site audit and make sure the records are prepared. Otherwise, what they're gonna say is you didn't cooperate, you refuse to cooperate, and then try to indicate that all those claims that fall under the audit are discrepant. Same thing. Desktop audit is paperwork, a lot of paperwork. They give you a list of prescription. They ask you to provide copies, front and back. Same thing for the signature logs, proof of payment, or even delivery receipts. Then they ask you to provide a list of suppliers, right? The wholesalers. The key regarding the wholesaler is that you have to request the wholesalers to provide the purchase report directly from the wholesaler to the PBMs. Otherwise, when the PBM is going to do the invoice reconciliation, they're not going to give any credit on those purchases not provided directly from the wholesaler. Okay. For both on-site audit and desktop audit, you usually have 30 days, 30 days to respond. Okay. And it's not the same for fraud, waste, and abuse investigations, which is a notch higher in terms of the concerns that PBMs may have. And typical fraud, waste, and abuse investigations, you have typically 7 to 14 business days to respond, or even calendar days to respond to the FW investigation. Next slide, please.
Yeah. And one point I wanted to make about something that Day said as we go on to the next slide is that notion of standing your ground while also cooperating with the investigation. And you can achieve both. And we'll talk about this too when we get into the Board of Pharmacy stuff. That's really why it's so important to prepare for, especially the on-site audits. And the reason being, you have advance notice that they're coming. But there's nothing wrong with professionally standing your ground and saying, I'm familiar with the audit laws of our state, so on and so forth. And I just, my understanding of the law, my reading of the law says you can't do this. And so I'm not going to allow you, and perhaps even document it. That's very different than just, completely refusing to comply with any aspect of the on-site audit. So just think about that notion of cooperating, but also finding a way to stand your ground in a professional manner, of course.
Are you guys seeing an uptick in on-site audits? Have you noticed that?
Yeah, definitely. I'm getting a lot of
Say that
background
we
noise.
are. And one of the other trends that I would say is that it seems to be in the aftermath of kind of like some people still have COVID fatigue. And one of the things we definitely saw is that in the 2 to 3 years following COVID, on-site audits were almost like not happening. And now I sense a little bit of making up for lost time. So I do think there's kind of a return back to pre-COVID on-site audit volume.
Okay. Yeah, that's what we were seeing.
But keep in mind, a lot of states have pharmacy fair audit laws, and then there are guardrails or guidelines or requirements for the PBM to conduct on-site audit. Like, for example, you have to give ample notice, whether it be 30 days in advance notice to conduct an on-site audit, or the on-site audit must be conducted within, first 14 days of a given month. Okay, so you have to know all these. I don't expect you, the pharmacists or pharmacy owners, to know every single bit of those fair audit laws, but just know that they exist. And then we could use them to our advantage to push back against PBM's, tactics. All right, just diving into the audit practices. Let me just quickly go over the life cycle of an audit. You get a notice of audit, prepare the document, submit the document, you get the initial findings. Once you get the initial finding, you have an opportunity to submit an appeal response. Okay. And you have to back up your appeal response, with the factual refutals and then as well as legal arguments, along with the supporting documents that are supplied to the PBMs in a well-organized manner. Okay. And then you get a final findings, and then you have another opportunity to submit an appeal response. But note that depending on which PBM it is, and depending on their provider manual, you have a right to invoke what's called dispute resolution meeting. And then we usually invoke after the receiver as part of the final appeal response. And we get to be on the phone with their in-house counsel or the panel, including their in-house counsel. And then we get to flesh out the underlying discrepancies. Okay. Now, copay, proof of copay, is one of the hot button items. PBMs have been using this discrepancy type many, many years, but they tend to update their provider manual and update to reflect new requirements, meaning supporting documents that will be ultimately, in their point of view, accepted by them. We usually provide receipts with last four digits of a credit card if it's cash, and then if you guys deposit cash, we provide the deposit slips. But in the more recent past, they started asking about merchant reports, like credit card merchant reports, which is not easy to get. And when we provide patient attestation, they tend to refute that we actually received those patient attestation directly from the patient, which has not been an issue. It had not been an issue in the last year, or the year before. But this is very recent. And then we try to fight the so-called authenticity of the patient attestation and the chain of communication. Okay. And more recently, they've been attacking claims that are received by the patients at long-term care facilities like, proof of co-payment collection. Do you actually get the co-payment from the patient at the point of sale? Maybe not. It could be the day before or a couple days later. So documentation is the key in fighting the copay discrepancy.
And I just have to add to that, Day. Day is 100% right. And I would add good documentation. Your documentation can never be too clear, so on and so forth. A couple of trends that I see that PBMs will assume fraud, waste, and abuse, fraud, something like that. Um, but there's actually a legitimate explanation. You go to get a patient attestation, you send out perhaps a delivery driver because they're used to face interaction with the patients. And they say, "Hi, I'm from the local pharmacy. I'm here to get this attestation because we're being audited by a PBM." First of all, they're probably like, "What?" But from there, you find out that they're happy to sign the attestation, but it turns out that the patient is actually out at the moment, but authorizes a son or a daughter or a husband or a wife to sign on their behalf. So then the PBM says, "This doesn't look like signature. We actually have a copy of this patient's signature and they don't match. We think it's a forged signature and equals fraud." Lo and behold, there's a very, very legitimate, plausible explanation. So those are things we want to take head on, account for. By the way, I would suggest there's nothing wrong with that per se. The key is making sure if that's the case that you tell the PBM that. Because there's not anything wrong with that per se. It's just making sure there's no confusion over why two signatures happen to look the same. So just
Wouldn't it
one
be
example.
pretty simple if we just printed out their name next to the signature so we knew it was Bob Brown, so that we're not have a chance of fraud? The signature we've got, in our attestation, maybe we add a printed name.
Yeah, I think those little things go a long way. And the other thing is, if you do run into the situation I described, which again is one of many examples, is just say, "Well, do you mind writing that on there? I'm Lucas Morgan. I am the son of so and so or husband of so and I'm signing on behalf with a authorization or something like that."
Sounds good. Next slide, please. Drug invoice shortage. Next big item that you usually see in the audit findings is at the end of the day, drug invoice shortage is should be a simple math. PBMs compare what you purchase, the amount of drugs that you purchase versus the those drugs claims billed. And then if they find a surplus or even the equal amount, then you shouldn't have drug invoice shortage. But they always try to get you on the drug invoice shortage by creating the notion of drug invoice shortage. Because keep in mind, the audit period is an arbitrary number. They say, oh, the audit period is January 1st, 2024 through December 31st, 2024. They're only going to look at the claim submitted during that period. And at best, they're gonna look at the drug purchased during that period, plus a month prior to that audit, beginning date of the audit period, meaning in that case, December 1st, 2023. But many pharmacies, they buy products sometimes in advance because you want to take advantage of any discounts that are out there in order to create the margin. Okay, right now everybody's dealing with the low reimbursement rate. So how do you create profit margin? You create profit margin by buying products at a lower cost, lower acquisition cost, right? Reimbursement rate is fixed. So you try to create the margin by buying the drug products at a lower price in order to create the margin. And sometimes you buy it in advance, right? Otherwise, so PBMs, they create this arbitrary audit period. They only look at the drug purchase during that period. And then they try to come up with the drug invoice shortage. And we have to fight that. And there's ways to fight that.
Yeah, we see that one all the time, Day. I mean, because people will do pre-buys, like they know brands are going up, for example,
Mm-hmm.
first of the year, and so they'll buy a bunch at the end, and then, they use them for quite a while, and it doesn't go back, and they won't accept, the stuff that they
Exactly.
bought in December, for example. So that this is one that we're seeing a lot of, and usually people have bought the drugs, and the PBM is not always willing to work with them to look at it. And we also struggle sometimes to get the reports from like smaller vendors.
Mm-hmm.
And so, you're trying to get that on time and get it out there.
Exactly. So you have to be vigilant. You have to be vigilant in terms of records keeping, in terms of tracking down all the purchases. And
And I
then,
totally agree with
Mhm.
Day on that as well. That notion of vigilance, and you, Owen, this is probably one of the most heavily relied upon types of audits in the playbook. And I think it's because they're very profitable and lucrative, meaning they can get a lot of money for a little bit of work. You spread that out over the entire,
I don't know. We have the same
exactly
thing
what we just
happening
talked about.
with our wholesalers.
What's that?
We have the same kind of problem with our wholesalers, like when we're trying to get our generic rebates. I mean, that
Yep.
they'll look at our purchasing patterns, and because we do not purchase exactly what we dispense, they'll try to withhold rebate dollars for the same reasons.
Yeah.
So you do have to.
And
So my point is, you have to keep these records because you're going to have to prove it to somebody at some point.
yeah. And here's the challenge I see. There is a direct correlation between the ability to provide records depending on where in the audit period it falls. The further back, the less likely you are to get the records. So what's the takeaway? What's the call to action? Start documenting your purchases with your own records as you buy them, assuming you're going to need them a year from now, 2 years from now. Because what I will tell you is, in kind of the litigator in me, I don't care what a PBM thinks. I always imagine what a judge or an arbitrator is going to think. And what's the standard when you're in litigation? Was it reasonable? And so I put up, is it reasonable to look at an inventory audit and say, we know you bought it. In fact, we know you bought it from someone we like. You bought it from McKesson. You bought it from Cardinal Health, Kinray. The list goes on and on. The only thing you didn't do is buy it at the exact right time that we like and we prefer. And what do we get to do? Well, if we're Caremark, we get to recoup 100% of the money plus a 20% audit fee. What does that start to look like? I mean, simply said, it looks unfair, but it also starts to look very much like purposeful and intentional to just gain a monetary benefit. And having that type of documentation in the context of a litigation is very, very compelling. So, and then the only other thing I would say is good purchasing practices. It is really worth the time and effort to buy from the authorized trading partners for Caremark, Express Scripts. If you're with Optum, NABP accredited, just be very careful about those few select wholesalers who are NABP accredited, but not necessarily an authorized trading partner. There's a few of those. And when I say that, I'm not saying I hold all wholesalers that meet the NABP accreditation in high regard, but if they're not also an authorized trading partner, they may not be counted in an audit.
And the other thing is that PBMs, they can withhold payment even before issuing initial audit findings, even before you have any idea how much the discrepant amount will be. And they're going to start withholding. And they can do it. We've handled those matters before, and it's happening more frequently. So the key is when you get a notice of audit, be vigilant, get the document, and submit the documents in a timely manner. And in terms of drug invoice shortage, make sure you provide all the purchases, but make sure the wholesalers actually submit those documents directly to the PBMs. And one way to confirm that is demand that you are copied in their submission to the PBMs. Next slide. Okay, so as part of the drug invoice shortage, one type of document that PBMs request, as I said before, is the wholesaler's purchase report directly provided by the wholesaler to the PBMs, right? Now, keep in mind, again, the audit period is arbitrary. Okay, so your purchasing data during the audit period may not support the claims bill during that period. How do you fight? You have to provide the entire dispensing report, not limited to that PBM, across all payers. So if your purchases and your billed amount for those drugs match, or you have a surplus of purchases, then there shouldn't be any drug invoice shortage. And regardless of whether the PBM continues to maintain position or not, at the end of the day, and based on our experience, we take these cases, arbitration or litigation, and if when we have enough purchases, we're gonna win that fight.
And
Okay.
you mentioned something there about showing them the dispensing report across like all payers.
Mm-hmm.
We hear a lot that, oh, I don't want to show them anything that they didn't ask for. I don't want to show them about other stuff, not because they're doing something wrong, just they don't want Caremark to know about their business. I think they're
Right.
skeptical of them, but it's interesting. You say, show them all of that because you can show that you're actually doing this correctly. Is that what I'm
Right.
hearing? Yeah.
Exactly. So show them nothing more, nothing less than that they requested. That's the default, right?
Right.
However, if you have purchases 6 months ago, that would suffice the drug invoice shortage, then I think it makes sense to provide the entire dispensing report and all the purchases and the claims billed, and then you compare it and you do the math. You got to do the math, okay? If you just hand it over to them, they're not going to do it.
Yeah.
You don't trust them. They're not going to spend hours and hours. It's not in their best interest to be fair during the audit period. They're looking to recoup money from you. They're looking to kick you out of network. Don't expect them to be fair. So you have to do the work.
Um, yeah, and we have one question. It said, are PBMs able to access our purchase history from wholesalers without our knowledge or permission? I would assume not.
No,
Yeah.
no, they should not. They cannot unless there is an ongoing investigation or lawsuit, and they could issue a subpoena. I
Yeah.
mean, they could certainly reach out to the wholesalers and they could try to get it, but I presume that the wholesaler is going to are going to refuse or decline.
Dave's exactly right about that. Like the only way they would is through a subpoena, and that means like that's a legal tool that has legal enforceability. But they can't just say, "Hey, McKesson, can you? We're doing some housekeeping here. Send us over the purchase records." And I would actually say that even requesting it in that fashion would be entirely inappropriate.
Hmm. All right, let's move on to the next slide. Drug invoice shortage and invoice reconciliation. I wanted to point out that there is an ongoing, this is a very fresh case involving AstraZeneca's product, Farxiga. Lucas and I currently represent many pharmacies who received a demand letter or type of a demand letter from AstraZeneca asking the pharmacy to provide dispensing report and purchasing report of all Farxiga claims submitted in 2024, or a notice alerting the pharmacist that there is the AstraZeneca noticed a discrepancy in billing pattern and dispensing pattern, meaning a pharmacy submitted X amount of brand Farxiga claims, but pharmacy's wholesaler reports show that pharmacy only bought, less than, the amount billed. And what is AstraZeneca doing? They want to recoup money because they paid rebates on brand drug claims, and they're looking for, you know, um, incorrect billing practices and dispensing practices. And AstraZeneca is not the first one to do so. Lucas and I have handled other manufacturer cases where manufacturer tried to recoup rebates paid on brand drug claims from pharmacies that didn't have enough purchases of those brand drug claims. Okay. Next slide, please. All right. So from our experience, PBM audits and the audit findings the intention is okay. I'll give him that. The intention is to find any um, overpayments, incorrect billings, incorrectly billed claims. However, PBMs have turned it into their own revenue source of revenue. They're looking to recoup. They're looking to kick you out of the network. Why? Because they not only want to make money, but they want to steer the prescriptions to their own. CVS, not only the retail, but they have specialty and mail order. OptumRx, same thing, mail order and specialty. Express Scripts, they have their own specialty, Accredo. The audits and audit findings have become egregious source of revenue for them, and they know it. They could deny all they want, but from our point of view, this gotta stop. Okay. And until there's a stop on it, we have to fight back. You can't just accept the audit findings, even if it's a small dollar amount, because you know what they're going to do? They're going to turn it into a basis of network termination. Maybe not now, maybe not tomorrow, could be 6 months or a year after. That's why you got to fight back.
Yeah. And on those smaller audits, I would just say you got to fight on those. The value of fighting an audit is not the stated dollar value. It's also your future participation in the network. And it's also protecting your name and your reputation vis-a-vis the PBMs. So I think that is a really, really important thing to keep in mind. And so what am I referring to? I'm referring to the $2,000, the $3,000, the $5,000, the $8,000 audit. I will tell you, I know for a fact, because I've literally heard clients say it verbatim, 10 years ago, 8 years ago, the idea was, it's just $2,000. I mean, I don't think it's right. I don't think it's fair. But if I let them take it back and they're going to keep me in the network, I just let them do it. And then guess what happened 5, 6, 7 years later? There was another $2,000 audit, another $5,000 audit. And then all of a sudden that third audit comes around and the PBM says, we now have detected a pattern or practice of concerning audit history. And then they take those small audits and just say, they may be small individually, but when you aggregate them together, what else is going on here? So just something to keep in mind.
Thanks, Lucas. Next slide.
And this is something I wanted to briefly just touch on as kind of a new development or trend. One of the things we are seeing is the addition of personal guarantee requirements to certain contracts. I don't want to sound any sort of a false alarm or make anyone think that this is, an avalanche of an issue, so to speak, but we are starting to see some PSAOs add personal guarantees as requirements to their contracts. The reason why this is relevant, two things. One, historically, this has not been the case. So, there's no doubt that as between a pharmacy and a PSAO, or as between a pharmacy and a PBM, there's been recourse to the business itself, to the pharmacy entity. But it appears that some of the PSAOs presumably have had legal financial disputes with PBMs that have resulted in them being on the hook for certain financial obligations that they otherwise would have obtained the money from a pharmacy that's no longer in the network. So this seems to be a way to mitigate certain issues or concerns between the PSAO and the PBM and their contract. And they seem to be mitigating that risk by adding personal guarantees to some of the PSAO contracts. So the main thing is, if you do need to sign this, get a second opinion, make sure you understand what it is. Is it really a personal guarantee? And again, the difference is, if you don't have the personal guarantee, they can certainly come after the pharmacy. But if you add to it a personal guarantee, they can also come after you personally and pursue personal assets. So we prefer to avoid that where we can for many different reasons. And I think this really comes from GER, BER true-ups. And I'm sure there's other reasons, but that's what I believe the origin of this lies in.
Lucas, can I say no? I don't want to sign it.
So the answer is yes, you can say no, but what comes after is a little tricky. So I would say the short answer is yes, you can say no, but there's a way to say no without rejecting the contract entirely. So,
Okay. How was that?
well, I think it's really one of the factors that comes into play is this a pre-existing relationship, or have you sought to apply to a new PSAO? So just a couple of quick examples, and I'm going to go to two extremes. One extreme is you just started up yesterday, brand new pharmacy, and you've now applied to a new PSAO to get the pharmacy off the ground and running and get into network with all your PBMs. If they say, here's our standard terms and conditions, and among them are a personal guarantee, a no to the personal guarantee is likely to be met with, well, then thanks, but no thanks. You just aren't qualifying in our network. Now, by contrast, you've been with the same PSAO for the last 20 years. You've run a viable business operation. You have no outstanding debt. There have been no major changes to the contract in the last 15 or 20 years, other than some details here and there. Then all of a sudden, out of the blue, they say, we're now adding a personal guarantee. There, I believe that you can say, thanks, but no thanks. We've never previously had this before. We've never had an issue with you. You know that we are a good pharmacy. We've never done you wrong, and we stand behind that. We want to keep working with you, but we are respectfully rejecting the imposition of a personal guarantee. Now, it may be that at the end of the day, you butt heads and can't come to an agreement on it, but I believe that a PSAO is more likely than not to want to engage in a discussion, or they may say, understood, we don't disagree with you, we're willing to withdraw that as a requirement for this particular relationship. So two very different examples. And this, I should have advanced this sooner, but again, this just goes on to those issues. The one other thing that we've seen this come up in the PSAO context, on top of the personal guarantee, is some other PSAOs taking a hard line position on pharmacies' ability to mail outside of their home state. And so, just to put a finer point on this, this came up, and I think this is kind of out there in the ether, so to speak, with AlignRx very specifically, where if they saw trends or indications of mailing beyond state lines, they seem to be taking issue with that. Still trying to unpack this one a little more to see if this is limited to certain geographic locales, if this is just a hard line in the sand, but it is a very recent development, so it's something to be on the lookout for.
And one thing I also wanted to mention about PSAO, when you walk away from an existing PSAO relationship, make sure it's a mutual walk away. Make sure it's not a termination, because if it's a termination, it's going to impact your next contract with PSAO.
And so just transitioning from kind of the PBM, the PSAO discussions into this notion of interplay between BOPs and PBMs, or state boards of pharmacy and PBMs. So very simple notion. What's the interplay? PBMs communicate with boards of pharmacy, and boards of pharmacy communicate with PBMs. How do they communicate? Well, in the case of a PBM, I've had very many cases where I've had a board of pharmacy move to investigate a pharmacy, and when I say, can you tell us the source of your complaint? Straight up say, we received a complaint from Prime Therapeutics. We received a complaint from Express Scripts. What is the complaint? It's not anything fancy. It's, we conducted an audit and we found X number of discrepancies based on drug invoice shortage. Nothing else. They're certainly not giving context or anything like that. So that is a clear example, and I have the sample size here is large. That is a clear example of direct communication between a PBM and a state board of pharmacy. There's other examples, but that's one clear one. Next, how does a BOP communicate with a PBM? There are many ways. I mean, in that scenario, clearly there's going to be back and forth discussion where the board of pharmacy, in addition to communicating with the pharmacy directly, is also going to want to make some inquiries to the PBM, get their side of the story. They also communicate through the National Practitioners Data Bank. the NPDB. This is big. This is why I have been preaching to anyone that'll listen that you really, really have to step up your state board of pharmacy game. And what I mean by that is I continue to represent tons of pharmacies and tons of pharmacists who are getting into trouble with their board of pharmacy for good old fashioned, I didn't know I had to do that. And it's relatively speaking, because there's nothing simple in the regulated professions. There just isn't. Pharmacists have a ton of responsibilities. So my heart goes out to you because I know how many hats you're wearing. But relatively speaking, as it relates to managing your relationship with a PBM, simple things like notifying them that there was a change in pharmacist in charge. Still to this day, that continues to be a frequent flyer issue for me. In other simple notifications, any form of reportable disciplinary action, it will be reported to the NPDB, and the PBMs monitor that. Every PBM has in their contract and provider manual some form of requirement to notify them of disciplinary action. I'm telling you right now that if you have disciplinary action with your board of pharmacy, you have to disclose it to the PBM. Day and I do this all the time. There is a way to eloquently notify a board of pharmacy that you have been subject to disciplinary action without losing the contract. That is the biggest reason that I see pharmacies withholding this information or not providing this information. I mean, the other reason is, again, just didn't know I had to do it. Setting that aside, they're like, well, if I tell them that I was disciplined by the board of pharmacy, aren't they going to terminate me? And the answer is most likely not, as long as you timely notify them of the disciplinary action. What is the exception? The exception is if you notify them of something terrible or egregious. And when I say that, I'm really talking in all seriousness about like patient harm, like something that seriously led to patient harm, anything that is a true indication of real fraud, like theft, those types of things, issues with opioids or controlled substances, that kind of stuff. Setting that aside, though, other proactively reporting disciplinary action with the board will usually preserve your contractual relationship. And I just want to be clear, because this is so often misunderstood. All disciplinary action, in my opinion, as a starting point, is created equal. It doesn't matter if the disciplinary action was a $500 administrative penalty for failure to notify the board of a change in pharmacist in charge, or if it was a $10,000 penalty for failure to comply with USP 800 immediately upon the new standards becoming effective. So very, very different issues there. What I'm trying to point out is it's still considered disciplinary and thus reported to the National Practitioners Data Bank, and therefore the PBMs will get notice of it. So that's why you really need to be on top of this stuff. Now, Day and I have been very successful in several jurisdictions of being able to resolve certain disciplinary proceedings in ways that are technically considered non-disciplinary and therefore not reported to the National Practitioners Data Bank. That's a game changer, but to be able to do that, you really have to be on top of this stuff and know how to navigate through this. So,
And not only that, the major PBMs, they require notification of any adverse action, including disciplinary action against the pharmacy owner, officer, director, and so on. Okay. And then they could use that in order to terminate a pharmacy from their network.
Does that also go to Employees Day? Like if
Yes.
employees have had actions?
Right. And especially if they are licensed professional, whether it be pharmacists or technicians, or if they hold any C-suite level positions, pharmacy manager.
yeah. One of the rules that I kind of live by is, and this assumes you want the like short and easy rules to live by. You will not get in trouble for reporting something you don't have to report. You will get in trouble for not reporting something you have to report. So how does this work? I'm telling you right now, so people will say, well, Lucas, if I don't have to report it and I don't, or if I don't have to report it and I do report it and then I get in trouble, then I'm going to look at you and say, well, Lucas, I didn't have to report it and I got in trouble for it. I can tell you right now, and I'm willing to put real money on this. If it's something you end up getting in trouble for, you had to report it anyway. So, in my point being is like the stuff that really matters to the board of pharmacy is almost always going to be reported. So I'll oftentimes get questions, and these are good questions. I'm not minimizing the significance of the question. Like, Lucas, do I need to report this? And this is from pharmacies or pharmacists that have become very hyper vigilant in a good way. So they'll say, Lucas, we just had XYZ. Do I need to report it? And I'll get them a definitive answer like, yes, you do need to report this, or no, you don't. Every now and then you have that like gray area where it's like, look, it's a little bit of a close call whether you have to report this, but I'm going to tell you you're better off reporting it and finding out you didn't need to than not reporting it and finding out you did need to report it. But at the end of the day, I've seen many pharmacies adopt a habit of erring on the side of just making a notification to the board. What's an example of this? Because you may be asking yourself, how many times you really have a brain buster on whether you got to report it or not? Well, it could be a simple change to a laboratory, like your compounding space in the pharmacy. So for example, let's say you upgrade a sink. Well, is that considered to be a renovation that needs to be disclosed and approved by the board? Or is that just a basic, change, like equivalent to changing a light bulb? Well, first, the answer depends on your jurisdiction, but there's some states that expect that to be disclosed to them. Other states will say that doesn't need to be disclosed because we don't consider that to be a renovation. That's just like basic maintenance, so on and so forth. But that's a perfect example of where I'm going to say, if hypothetically, if you're in a jurisdiction that didn't require disclosure of that, you're not going to get in trouble for reporting that. The other big thing to keep in mind with state boards of pharmacy, and it goes back to disclosures, is if you are a pharmacy that's licensed in any other states, so all it takes is one, is you're also preserving your relationship in those states. Because in addition to the fact that PBMs require disclosure of any board of pharmacy disciplinary action, so too all other jurisdictions require disclosure at some point in time of other disciplinary actions. So my home base is North New Jersey. So I happen to represent a lot of pharmacies that even for seemingly smaller operations will oftentimes maintain a license in New York, New Jersey, or New Jersey, Pennsylvania, sometimes all three. So I see a lot of that. So let's say they have an issue with the Pennsylvania Board of Pharmacy. Right out of the gate, they would need to disclose that to New Jersey and New York. I'm telling you right now, I know for a fact you got to report it. The only question is not if, it's when you need to report it. And some states require affirmative disclosure within a certain period of time of the event. So it might be 7 days, 10 days, 2 weeks, 30 days, 60 days. Other states say, you don't need to tell us the moment it happens, but we do inquire about this during your renewal process. So at some point it's going to come up.
And the same thing for PBMs. Let's say you get disciplinary action by a board, you don't report it to the PBM within, a certain amount of time, usually within 5 to 10 business days. They're going to ask you during a recredentialing. And if you don't answer truthfully, at the end of the day, they're going to find out. And that's a basis for immediate termination. And then once we notify them in a timely manner and they try to terminate you, we can fight that fight. I'll take that fight any day and night.
Yeah. And the last thing I just want to reiterate on this point, this idea of notification, and I say this because I'm at a point where I've worked with so many clients on this kind of uncomfortable notion of, you're really going to like serve this up on a silver platter and write a letter where you tell them that I got in trouble and you're also telling me that it's not going to cost me my contract? And the answer is, yeah, that's what I'm telling you. Now, there's an art to it. Like, you don't just send a notification that says, we're hereby letting you know that we were recently disciplined by the State Board of Pharmacy in our home state of, and I'm just saying New Jersey because that's, where I live. See attached. And then what is the attached? A copy of the order. Here, that is not how you do it. There is a way to articulate what happened, the position you took, what the final outcome was. So one of the things that I insist on when I'm representing a pharmacy in front of a board of pharmacy, if we come to a settlement or a consent agreement, is at the bare minimum, I want to be able to incorporate what we call statements of mitigation in any sort of a consent agreement. These are facts or realities that help to support the pharmacy and show that the pharmacy, despite this issue, is still, a good above board operator and a good pharmacy. And by the way, it's very important to point out that when it's all said and done, typically your license remains in good standing. Now there's exceptions, of course, because you have things like probation, suspension, so on and so forth. But normally the outcome of a disciplinary action by a board is your license remains in good standing. Those are really important things, both on the BOP front, that notion of statements of mitigation, but then when you're communicating this to other third parties, highlighting those facts and putting everything, I always say, control the narrative and make sure you put everything in its proper context. And I think I know we're coming up, we have about 9 minutes before the hour, but wanted to carve out just a couple extra minutes if there are any final questions.
There's actually a good amount. We'll get through as many of them as you can. If we can't get through one and you still want it, they'll put up their contact information. You can reach out and reach out to Day or Lucas, and I'm sure they'll be happy to talk to you. Or you can reach out to us and we can give you their information. So one was, are there any statistics on audit frequency from each PBM? Have you guys seen anything like that? I
We
haven't.
were just talking about it
Oh,
during our lunch meeting. Lucas, you want to take that? The busy season, and then there's a little bit of a.
Yeah, no, I mean, I would say that the bare minimum is that you should expect to see one audit per year from a PBM, except that they can conduct different types of investigations or audits within a given year. So, on-site audits are typically going to be limited to one a year. I would say desktop audits also are more likely to be like a full-blown desktop audit, more likely to be once a year. But keep in mind, if they all of a sudden put the moniker of fraud, waste, and abuse investigation, then any sort of state limitations on the number of audits from their perspective goes out the window. Now, I don't agree with that, but I think that's kind of a good rule of thumb, is kind of like 2 to 3 of each of those type within a 1 to 2 year period.
But
yeah.
we've seen a lot of termination activities around major holiday, like
Huh.
End
you
of
know,
year.
yeah, end of year. Like for
It's
example,
unfortunate, but it is a reality.
Interesting.
December 24th, Christmas Eve. Like there's so many times where I have to be hopping on a call with a client who just got a notice of termination.
Oh my gosh, that's terrible. Um, so another one was, and I assume what they mean by this is like Match RX and stuff. It says buying from online marketplaces. They put that in when you were talking about the inventory and where you buy from. Thoughts on that?
Very big issue. I would say I don't cast any aspersions on those marketplace platforms. What I would just say is buyer, make sure you're very cautious with those purchases. Again, I think those platforms serve a very, very valid purpose, but the key is making sure that you can show your work, both in terms of your engagement with the platform, but also with where the product came from directly. Things like asking for pedigree, your T3, those things are going to go a very long way. So I'd say, so long as you're applying those same principles that we talked about earlier, did the party that is putting this on the platform acquire it from the likes of McKesson, Cardinal Health, Kinray? Those types of things go a long way.
Wow.
Exactly.
Um, this question came up a couple times regarding DSCSA and how that's going to relate to PBMs. Are the PBMs even tracking DSCSA yet? Is that
PBMs are tracking in a sense that they require pedigrees. They require pedigrees during invoice reconciliation audits. And that's why it is important that, even if, whether you use get your products from reputable wholesaler or a secondary wholesaler or even through the marketplaces, make sure you have the right documents. Okay, you have the pedigree that's showing the transaction history information and statement, showing the lifespan of that product from the manufacturer to wholesaler to the ultimate buyer, independent pharmacy.
now they're not going to have access to those reports. You would have to provide those, right?
Correct. You would have to provide it or direct the wholesaler to provide it for you.
Right. Okay. Um, Another one was if is it up to the PBM to offer arbitration after final findings, or does the pharmacy have to request that?
Pharmacy needs to request it. Arbitration also is like not necessarily a request. It is something that is filed. And so what I always say is, and I'll just tell you right now, the way I handle business is I don't make empty threats. So I will strategically threaten arbitration where appropriate, but I will only do it once I have true buy-in from the client. But once you've made that decision, you don't need their permission. You just file the arbitration.
Mm.
And that's why PBMs know that when we bring that type of thread, they know we're serious, not just empty words.
Yeah, that's good. Okay. Um, Another question was, you guys were talking about the PBMs telling the boards of pharmacy, but do other PBMs tell other PBMs?
I would say that's far more limited, but there are definitely some indications that they do talk PBM to PBM, but I do think it's reserved for kind of the more serious issues and concerns, where they really think they've found something of a serious concern. But I don't want to say it can't happen or that it doesn't happen, but I do think there is some restraint there because do keep in mind they are competitors.
Right.
But at the same time, they use the same lobbying group.
Yes. It's kind of one of those, they join forces when it benefits them, but then they're completely separate and distinct when it, is to their detriment to be kind of directly associated. So they have no problem filing a lawsuit as a team in the Eastern District of Missouri to challenge, administrative proceedings at the regulatory level out of DC. But then when it comes to some claim of monopolization, they're like, oh my gosh, are you kidding me? I don't even know who those guys are.
That
Very
sounds about right.
slimy. Very slimy.
Yeah, I hear people think that the PBMs talk to each other all the time, and I wasn't sure if that was true.
Yeah.
Another question around signatures was, you get a lot of signatures on signature pads that are basically, and you can't read them, right? They use the electronic signature pads. They're choppy or they just scribble it. Is that a problem? Do they, like, if they can't tell whose name it is, does it matter or?
It's a problem if PBMs turn it into a problem.
Uh,
I think the key is you just need to have Dave's exactly right. And you just need to have some comfort that it's a real signature. Like if you get an attestation, I know these can be obtained 5 different ways. You send them an email with an attachment, print and return. You show up at their house or their doctor's office in person, whatever it is. If your immediate instinct is like, that's going to be a problem, respectfully see if you can get a better signature. But if that's their real deal signature and especially if you saw them sign it and you can vouch for it, that's a little better under that circumstance.
Okay, that's great. There's still a lot of questions, but we're up on time, and I am sure you guys probably have another call. So, hey, we really appreciate this was extremely informative. So I learned a lot today. It was great. Wait, I planned on interrupting you a whole lot more, but the information was so good that I'm just listening. So,
Yeah, thank you guys. Good
we really
job.
appreciate it.
We appreciate it. Thank you.
Thank
Yeah.
you both so much. And to everyone that tuned in, really appreciate it. And don't hesitate to reach out to Day or I informally.
And again, this has been recorded. We'll put it on our website, independentrxconsulting.com. If you follow me on LinkedIn, it'll be there too. We'll be sending out an email. Thanks again, Day, Lucas. Talk to you soon.
Thank you. Bye bye.
Thank you all.